Welcome back to another session. Hope you had a wonderful weekend. I did. So this session is brought to you by Accent Nominees, and the name of your host is Tomi Ogunle. Today's topic is partnership in Nigeria, guidelines for registration. So partnership is not a new type of business in Nigeria. It has been in existence before we even start thinking of establishing business. How? Let me give you an example. So where two brothers decide to come together to do business, that's partnership. Or where you and your friends come together to do business, that's partnership. So it is like an arrangement or agreement of two or more people with the common intention to do business, and then with the intention to make profit. And profit and liabilities are shared equally. So in other words, it is the coming together of two or more people to establish a business with the common intention to make profit. So in a partnership business, all partners, they share liabilities, they share profit equally. It doesn't mean that when two partners come together or two or more partners come together, one person cannot be like taking on the liabilities. Though I will have to get deep into this topic for you to see the ones that actually take liability. But for now, all partners take liabilities and share profit equally. From what I've said so far, we can deduct three essential ingredients from this definition, which is it must be a business. Then there must be common interest, that is consensus addendum between all partners, and then the partnership must be profit-oriented. It wouldn't make sense if 4 or 3 people comes together to do business without the intention of making profit. Then that's not business. And then it has to be a business. And partnership is not run by one person, 2 or more people have to come together to run the business. And then generally, a partnership is like a sole proprietorship where the business is inseparable from the business owners. That is, in the case of liability, business owners and their business, they are inseparable, they are the same. So partnership in Nigeria is actually regulated by the Companies and Allied Matters Act 2020, which is popularly known as the CAMA 2020, and it is also regulated by the partnership law of each state of the federation. So according to the CAMA 2020, the maximum number of people that can come together to form a partnership is 20, which I'll have to explain further in today's discussion. So the foundation of partnership is mutual faith, trust, honesty. It wouldn't make sense if people come together to do business without trusting each other. Trust is actually important. You need to be honest. All information regarding the business needs to be disclosed to other partners. And it will be dangerous if you don't trust each other, or if you guys don't have faith in each other. It could be dangerous and risky for the business. Also, a partner cannot make unauthorized personal profits. Any money you're trying to withdraw, you need to let other partners know. It has to be with the consent of other partners. So the Company and Allied Matters Act provided for 2 types of partnership, which I'll be explaining, and they are the limited partnership, limited liability partnership. I'll be taking the limited partnership, which is the LP in short, and that's LP. So a limited partnership is a type of partnership with at least one general partner and a limited partner. So a general partner, I'm very sure you're wondering what a general partner is. If I'm talking about limited partnership, why should there be a general partner? Thank you. So the law provides that for a limited partnership, there has to be at least one general partner and then other limited partners. So the general partner is the one that actually oversees the running of or the day-to-day activity of the business. They are like really involved in running the business. And then when it comes to liability, they are the ones that will bear personal liability. So whereas a limited partner is one that his liabilities are limited to the money he contributed when they are about to establish the business. So a limited partnership cannot have more than 20 partners, and they may also have a corporate entity, meaning a partnership is not only limited to individuals. So individuals and corporate entity may come together to form partnership. In other words, partnership is not for individuals alone. Corporate entity may also come together with an individual or with individuals to form a partnership, which I already said that a general partner is the one that is in charge of the day-to-day activity, day-to-day running of the business, which he also bears liability. But there was a time I was just raising, like, how would I put it? I was raising a suggestion, and I was saying, who would like, how will I put it? Who would volunteer to be a general partner? Because I know I can't volunteer to be a general partner, where I know that I'll be the one bearing personal liability. I don't want to do that. I just want to be there, and all my liabilities to be limited. So why would I like? How would I like bear personal liability? But someone replied me and said most people like taking risk, which you could be the one. So far what I've said is that for a limited partnership, there has to be at least one general partner and limited partners. So limited partners do not have authority to bind the partnership, but they are authorized to have access to partnership books. So at the time of partnership formation, each partners, they must agree or invest or agree to contribute capital to run the business. Of course, before you can run a business, you need capital to run the business. When you come together to run business and then there's no capital, I'm very sure you can't get anything. You can't even run anything. So each partners need to come together to agree or that this is how much I'll be contributing, this is the amount I'll be contributing to run this business or to establish this business. So a limited partner cannot withdraw or receive money without the knowledge of other partners. Like I've said before, the foundation of partnership is mutual faith, trust, honesty, and disclosing confidential information when you need to, like among partners. You don't need to hoard any type of information, especially when it's important to the business. So how do you incorporate limited partnership? There's no difference between normal incorporation that would know. So availability and reservation of name, where you need to check if the name is available in order not to use existing name, because even CAC would not approve the name if it's already existing. And then once you already know the name is available, you reserve. Then after reservation, you draw up a partnership agreement. Then passport photograph of all partners. You need to submit that's to the CAC, and then means of identification, which is very important. I would suggest to use your NIN, because that's one of the current policies of the CAC. So after you fulfilled the requirement of incorporation, CAC will then register it, and then they would issue you a certificate of incorporation. You'll be issued certificate of incorporation. So the next one I'll be discussing is the limited liability partnership, which is also known as the LLP. Most times you see companies that end with LLP, just know that we are talking about the limited liability partnership. So a limited liability partnership, upon incorporation, becomes legal entity. That is, they are separate from its owners. The other one I said they are inseparable. So now these ones are separate, means they are seen as artificial body under the law. Like they have perpetual succession, they can sue and be sued, things like that. This is basically seen as a company, like it has this company features, just that it is partnership. So this partnership has perpetual succession, like I said, and it must have at least minimum of 2 people will have to come together to. Of course, partnership, you need more than one person, which is minimum of 2 people. And then the good thing about this is that, unlike the limited partnership, there's no maximum for this. The other one I said the maximum is 20. So for this, there's no maximum. That's according to section 748 of CAMA 2020. And then the LLP is also like a corporate body with legal personality. That is, it is separate from its owners. The company will stand alone and the owners will stand alone. So in a circumstance or in a situation whereby the company is indebted, the owners would not be the one bearing the loss. It will be the company. And then where they cannot afford to pay, they won't use their personal money to pay such debts. So it can sue and be sued in its own name. So if you want to sue so LLP, you can sue them in their name. And they can also sue you in their name. So it has perpetual succession, meaning the death of one partner does not terminate or dissolve this partnership. So where a partner dies, doesn't mean that's the end of the partnership or the partnership is dissolved. No, the partnership will actually still go on. Or where there is change in partnership, that is where there is inclusion, exclusion, is either by death or when they bring in new people, the right of partners would not be extinguished. The partnership is still in existence. So partners have limited liability. I already said for limited liability partnership, I know you'll be wondering, don't this one have a general partner? actually this one has, but it's not general partner. It is known as the designated partner. So at least there has to be 2 designated partner for the limited liability partnership. So their liabilities are limited. That's to the limited partners. Then there has to be at least 2 designated partners. One must be residing in Nigeria. That's actually very, very important. That's what the law says. So where there's 2 designated partners, you must make sure that one resides in Nigeria. So I'm very sure you're wondering, what is the designated partner? It is the same, almost the same with general partner. It's just that the names are different. So the designated partner is a partner of a limited liability partnership with additional responsibility from other partners. So some of the responsibility a designated partner is the performance of all acts, matters, and things that is related to the limited liability partnership. That is when it comes to compliance matters with the CAC. And then they file documents, returns, annual returns, statements, and other reports under CAMA. So a designated partner would be liable for any penalty that is imposed on the LLP by the CAC. I'm very sure you're wondering, what do I mean? It means if there's a penalty that is imposed on, a penalty that is imposed on the LLP, it is the designated partner that will be responsible, not the other partners. I meant the designated partners. So who would volunteer to be a designated partner? Because I've said it wouldn't be me. I want to be a limited partner. I want to be a limited partner. So in other words, they will be liable for failure to comply with the provision of the CAMA. So there are some circumstances whereby some things that you need to do. People that are running up and down will be designated partners because they know that if they don't do these things, there will be penalty for them under CAMA, and they wouldn't want that. So for you to register LLP with the Corporate Affairs Commission, the promoters of the partnership would require certain information, but they are not limited to this. Please, I'm saying it again, they are not limited to this. Because of time, I would not be going into everything. So, as I said earlier, availability of names. You check if the names you want to register are available. And then I suggest you drop 2 names. So when one is not available, the other ones would be available. That's 2 proposed names for the LLP. So business address and email address for the firm. That's for the for the firm, the office you want to use. And then personal information of partners, such as phone number, their address, date of birth, email address, etc. And then means of ID for partners. Like, if you know you want to be a partner, you need means of ID. And then an executed partnership agreement. I will be explaining this also because I'm sure you'll be wondering what is the partnership agreement. So upon fulfilling the necessary requirements of registration of an LLP, the Corporate Affairs Commission will register the partnership and issue certificate of incorporation. And then a limited partnership must end with either an LLP or it must end with limited liability partnership. So I'm talking about the partnership agreement. From the conversation and discussion we've been having so far, if you remember, I've been talking about partnership agreement. So what is partnership agreement? It is like a legal contract that contains terms and conditions that governs the way partnership will be operated, like the way it will be operated between parties that are involved. You know, I said something that who will volunteer to be the general partner or designated partner. So in a situation whereby you guys don't have an agreement to regulate it, you just say at the point of registering or formation of the stuff or a formation of a partnership, I just volunteer that I'll be general partner and then you guys can be the limited partner, and then glory be to God, there is a penalty I need to pay. I was just start saying I was not a general partner. I never volunteered to be general partner. Then how do we ascertain this? This is where the partnership agreement comes into place. So where everything is stated in the partnership agreement, it will be easy to ascertain who the general partner is, who the limited partner is. You can't even change mouth, and it is always easy because the court is always ready to enforce a written partnership agreement. So I would not advise you to go for oral partnership agreements. So it is advisable for you to draw up a formal agreement because it is readily enforceable by the court. A partnership agreement makes it possible to easily ascertain terms and conditions and stipulations of the agreement. You know, how much profits are we to distribute, how much is going to you, how much is going to you. Not as if you just say it. These things need, because it's not business of one person anymore. So many people are involved in this partnership, and then people need to be held accountable. When I said trust, honesty, faith, everything is the foundation of a partnership. So imagine where this is not there. How will you hold people accountable? It is with this partnership agreement you'll be able to hold people accountable. So what are the content of partnership agreements? Of course, we know parties, you know, people that names of partners, then commencement. That is where the partnership it is to commence. When is it to commence? Then the full names and descriptions of all parties involved. So whether they are designated partner or they are limited partner, it will be stated there. And then the general and specific nature of the business. That is the business, all partners like come together to run. You know, I said it has to be a business. So which business do you intend to run? Is it shoemaking? You know, which type of business? And then place of business. Is it Lagos? Is it Abuja? Is it Maiduguri? Depending on where you guys have decided to use. And then capital of the business. If you also remember that I said partners needs to agree or needs to invest or they need to contribute certain amounts as capital to run the business, which is also important. So property of partnership, you have to state that the sharing of profit and losses, that is how much, because most, I know I already said it, me, now, I want to be a limited partner, whereby I just want to donate money and not do anything, and end of the day, money is coming to me. You can also do that. That's where the limited partner is. Easy life. Do you understand? So, in this situation, how profits will be shared and how losses will be shared would also be stated, and the remuneration of partners. If it's not stated there, then partners would not be getting remuneration. Then suspension and expulsion of partners, because if it's not there, then how do you want to, in a situation whereby a partner is responsible for gross misconduct, how do you suspend, how do you expel such a partner when it is not stated? So no partner can be expelled or suspended irrespective of his conduct if it is not clearly stated in the partnership agreement. So if any partner is expelled or suspended, it is determined by the partnership agreement. Then admission of new parties. You can, along the way, okay, we feel like we need to bring in more people, or maybe, I'm telling my friend, I'm doing this partnership stuff, and then you can also join us and we can run the business together. There's nothing wrong. You are bringing the person. So in the partnership agreements, ways of admitting new partners will be there, because if not, I can go meet my family member and we'll be doing the partnership together. If there's no partnership agreement, so it should be clearly stated in the partnership agreement. And then the next one I'm talking about is cessation of partnership agreements. How can we end it? Like, how will it end? Upon a death of a partner, that is not in all circumstances, it depends. And then upon dissolution of a partner, that's partnership interests of a person. Then where a partner is declared to be of unsound mind, then, you know, other people will be, you know, enjoying their rights, but you can't enjoy yours, like your interest, because you're of unsound mind. And then where a partner is declared insolvent. So, in conclusion, it is the preferred form. The preferred form of partnership is largely it largely depends on the purpose of which the partnership is established, or the nature of the business. How will I put it? It depends on okay, I like the LLP because there's no maximum numbers, and that's what I want. Okay, I want the LP because it's just 20 people. I don't want too much people. When people are too much, the business does not move. That kind of thing. So it depends on what you want and the purpose you want to achieve with the partnership. So it will help you decide what kind of partnership you need to go for. Me, from my own opinion, I can go for any partnership, but I'll say it again, as long as I am the limited partner, I'm not the one taking responsibility taking personal liability, you know, that kind of thing. And then most times we advise that any individual or corporate entity that is seeking to register any kind of business or partnership in Nigeria to seek proper legal advice on the preferred kind of partnership he or she or you think your business would need. I hope you enjoyed today's session. And then before you go into your partnership business, think well. And then if you know that you're not getting it or you feel like you are stuck, then why don't you seek help of a professional person or a professional body that would put you in the right place or direct you in the right place, so you wouldn't make a mistake later on. It wouldn't make sense if you're already into a partnership agreement and then you're already making loss. You're like about to like leave and you say, okay, you're leaving so amount, and then just find out that what you signed was not right, or there was no even partnership agreement to begin with. Like, where do you want to start from? Or you just to conclude that we had oral partnership agreements. I'm not saying that's not acceptable. I'm just saying it will be hard to enforce. It's not really enforceable. So before you do any type of business, reach out to people that can guide you, or of course watch our videos and pick one or two things that could be helpful to you. Thank you for joining us. I hope I see you next week, same time. God bless you.